The American civil justice system is part of what makes America great. It's designed to be a force for good and correcting harm, ensuring justice against wrongdoers, and deterring future would-be bad actors. I've long recognized the importance of this system, and I continue to work with members of this committee, ensuring, for example, that American victims of terrorism are able to bring civil action in U.S. courts against people responsible for that terrorism. Given the importance of these and other purposes, I'm all the more frustrated when our legal system and the rules that govern it is abused, bogged down with meritless claims, or twisted to benefit some at the expense of others. I'm frustrated when this system is used not to correct a harm, but to inflict one. This committee should be looking into ways to improve the civil justice system and push back against misuse and abuse. And so today's hearing serves as a necessary and overdue checkup of that system. We're here to examine in particular the impact that lawsuit abuse has on America's small business and other job creators who drive the American economy. The sheer cost of modern litigation on time, on emotions, and on financial resources of the parties involved has become a leveraging opportunity for those who wish to make a quick buck. This is particularly true in the small business sphere. I hear more and more about small businesses across the country and in my home state of Iowa getting hit with frivolous demand letters and lawsuits. Given the cost of litigation, the mere threat of a lawsuit, even one unsupported by facts, can force a small business owner to open his or her pocketbook to quickly settle a claim. Often, this does little to resolve any alleged injuries and to solve the problems, but conveniently, it puts money into lawyers' pockets. These claims, these settlement shakedowns come in many forms. I'm going to refer to a 60-minute episode highlighting the rise of so-called drive-by litigation under the Americans with Disability Act, a very good law, by the way. In some cases, lawyers will simply drive down the street or even use pictures on Google Maps to look for any possible technical violation of the ADA by local businesses. This is quickly followed then by a demand letter to the business, or a lawsuit would prevail or come about. Instead of seeking a correction to the alleged violation, the demand letter offers the business owner an out through a quick settlement. According to a letter I received from Taco John Restaurants of Iowa, quote, the main incentive in these actions is forcing a monetary settlement consisting principally of the attorney's fees from community businesses like mine, end of quote. Our overly litigious society has led to some absurd results. Earlier this year, a woman sued a restaurant in Florida for negligence after she climbed on top of and subsequently fell off a decorative statue of a donkey inside the restaurant. Months later, the lawsuit was dropped, but only after the restaurant had spent time and resources for legal counsel. These cases have very real costs. Money that could be spent hiring new employees is instead funneled into legal expenses. Small businesses across the country face similar threats of abusive litigation every day, costing us jobs and obviously hurting economic growth. I have heard from others, like the Accredited Snow Contractors Association, which represents the snow removal industry, that frivolous claims are causing dramatic spikes in insurance premiums, driving an entire industry out of business. These are hardworking Americans creating jobs and taking care of their local communities, but they're being buried in abusive litigation. We need better deterrence. We need predictable sanctions against those who misuse the justice system. And business owners should have confidence to challenge a bogus claim, knowing that they'll be compensated for their time and resources spent fighting back. But current litigation rules don't provide much help. Right now, federal rules say that even if a lawsuit is found to be frivolous, a judge can simply decide against sanctioning the offending party. I've introduced a bill, the Lawsuit Abuse Reduction Act, to put teeth back into these rules to better deter harmful, abusive, and frivolous litigation. We'll also hear today about other tactics that unnecessarily drag individuals and small businesses into litigation purely for the strategic benefit of plaintiffs' lawyers who'd prefer to keep their case in a friendly local court. And of course, another area really ripe for examination is class action litigation. Over 10 years ago, Congress passed the Class Action Fairness Act, which I introduced. The Class Action Fairness Act brought about much needed reforms aimed at improving a system chock full of abuses that harmed America's job creators, allowed lawyers to game the system for their own self-interest, and often resulted in little, if any, real recovery for class members. I was pleased to have the support of Senator Feinstein and both sides of the aisle in that effort to get that problem corrected through that legislation. Today, we'll hear about other abuses and concerns that have since developed, which are once again twisting the system in a way that puts the lawyer's interests first. So these and many others are important issues that need to be sorted out. So I'm pleased that we have this opportunity today to hear about our civil justice system falling short. We have an excellent panel of experts who will shed light on these concerns, and I hope today that the start of a productive dialogue will begin in this committee. Thank you all for being here, and now